I heard a rumor. I heard 10,000 people want to sit and listen to us talk. Do you believe that? I don't believe that. Do you believe that? No? That's right. Only 9,998 of them want to see the subtitles. The other 2 want to listen to us talk. Right? Okay. Okay, we got it now. We understand. But today, we want to say thank you for everything, for loving us, for being there, for hitting the subscribe button. Even though 80% of you don't, we still love you. And for everyone who was concerned about Penny's lump, I was very concerned because Penny had a lump. I took her to the doctor. I took her to the vet, the doggy doctor. Penny's okay. She's okay. It's not a lump. No, she's just fat. Oops. Overactive mom. See, I'm just fat. That's all it is. Oops. Thought it was a lump. What can you do? So, I woke up at midnight last night. I've been trying to figure out what to do for this stream forever. And I saw a crazy sentencing. And I followed it all the way back to the headlines. And I thought, how cool. Let's watch a case from the headlines all the way to the sentencing. Oh, Tiff, go put your groceries away. We won't do anything exciting, I promise. Don't tell her. Groceries. She needs food. Yeah, food's important. But before we do, someone sent us a special message that I thought you should see. Because, you'll like him more than me.
Hello, I'd just like to say congratulations to Meg's Crime Watch for getting 10,000 subscribers. I remember when you were this big. Keep up the good work.
I have to say a huge thank you to Mike and to Biggin because Penny wouldn't be here looking all fab without them. And I wouldn't be here without Penny. So, if you go down the chain, it's because of Mike and Biggin that I'm ultimately here. And Penny, but mostly Mike and Biggin. They were incredibly supportive, helping me get the channel off the ground, and they've been awesome all the way through, giving me advice and telling me when I'm doing stupid stuff. But you guys are too. You have no problem telling me when I'm doing stupid stuff. So I appreciate when you tell me when I'm doing stupid stuff, and I appreciate when you tell me nicely. Oh, look, my eyeshadow matches my shirt for you. I got all dressed up. I even tried to do my hair. That didn't work. So you know how some people don't like to give their advice nicely? So we have a new mascot for them. Guess what he's called? That's a donkey. What's another name for a donkey? And he's wearing a hat. I can't say it yet because it's not 8 minutes in, but you know what it is. That's for those you know what people. So we're going to start using him. He even has a donkey sound. Love it. Okay, so I didn't think I could properly give you a preview of this case. Oh, and we've added some cats to the pup cam, just so you know. I'll have to turn the labels back on, but there's a little cat tree action in there for you. So I put together a little preview for you. If you all are ready to go, thank you, thank you, thank you. I appreciate everyone, and I hope that I have killed enough time so those of you who just got here don't have to watch on 2 point whatever speed, because that can't possibly be fun. Welcome, welcome, and thank you all so much. It really means a lot to me. I can't tell you how much it means. So let's get it started while the dog digs in the bed. I've never understood the digging. Where are you trying to go? To the floor? I don't know. Here we go. On the afternoon of September 1st, 2022, a 911 call came in from the Blissfield Township in Lenawee County, Michigan. The report was of an unresponsive 2-month-old baby boy. The police chief was the first to arrive. He performed CPR on the boy until paramedics arrived, and they rushed the boy to the hospital in Toledo, Ohio. Just as the ambulance was arriving to the hospital, EMTs detected a pulse in the baby boy. The chief would later tell 13 ABC News they believed the baby was down for at least 45 minutes and maybe as much as an hour and a half, so the fact that they could get a pulse back was nothing short of a miracle. The child's father, Christopher Diethos, was arrested on charges of child abuse. The baby remained in the hospital for the following week, then unfortunately passed away on September 8th. The cause of death was listed as shaken baby syndrome. The Blissfield police were told by a doctor at ProMedica Toledo Hospital that the child's injuries were consistent with having been shaken, and Diethos told police he shook the baby when the baby wouldn't stop crying, according to the affidavit of probable cause filed in district court. An additional charge of homicide, open murder was added, and Diethos' bond of $500,000 was raised to $10.5 million. A competency hearing was set for January. In mid-December, his case was bound over to circuit court, which is where we pick up the case, in Lenawee County Circuit Court. Not the funnest case ever, but we don't talk about what happened. We don't talk about injuries. We don't talk about anything like that. All we really talk about is the legal process until the very end. And in the end, we still don't talk about details. So I figured it was okay. The premise sucks, but we're not talking about it. It's sad overall, but I'm looking at it more as it's very interesting to see the process from start to finish, and there's a little bit of a twist in this one. So it's, like I said, we're completely talking about legal stuff, and the only thing they do at the very end is say, he says, I shook the baby because it wouldn't cry. That's all they talk about. They don't, nothing more than that. I promise, or I wouldn't have aired it. So no, and I don't know that I want to. I guess it's kind of different when they're first born. You really got to shake them. So anyways, they ordered the competency hearing in circuit court, in district court, which, you know, district court is below circuit court, and we don't have any of those videos. There were a couple hearings just checking on status, which I'm assuming they said in every one, yeah, we need more time. So we basically pick it up in circuit court where they're checking status, checking in for status. And that went too fast. I've added in the docket because I think it's interesting to look at what's going on in the docket as we're doing it. So you can see the prosecution and the defense going back and forth for discovery. The clerk put in a note that the system wouldn't let her put in the $10.5 million bond. And then the next hearing is scheduled for December 28th, and that's where we pick this up. So right here, you can see Christopher Diethos. That's actually our defendant. And I left this part in because I thought it was a little bit interesting. He's on the camera and he's completely fine, and he's sitting there and he's waiting. And John Glaser at the bottom, that's his attorney, and you can see the judge at the top. And they're having the hearing for the gentleman in the middle, and he's sitting there watching, and it's no big deal. And in just a minute, he reaches up and he turns the camera off. Like right there. And then he leaves the room. And then the volume should kick back on in a second. Sorry. But there was no reason for it. And it's just a little odd. And his behavior is a little odd through the majority of this.
All right, Mr. Glazier, I have Mr. Dietos, but I lost him. Where'd he go? Oh, he's in. I lost him. Where'd he go? All right, well, I had him. But now I don't. All right, what was your name again? All right, Mr. Dietos, sorry I lost you.
I accidentally left the meeting. I forgot to put got it. I'm in the other room, so.
It's okay. It's okay. Let me find you. Not a problem. You said your attorney was Mr. Glazier, right?
Yes.
File. All right, in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Dietos, and I have Phoebe Meir appearing on behalf of the people. This is a date and time set for arraignment in this matter. Mr. Glazier, have you received a copy of the felony information?
Yes, I have, Your Honor. We'd waive the reading of that. Enter a plea of not guilty and ask this matter be set for a pretrial, Your Honor. We would ask that the court order an evaluation on criminal responsibility. It was ordered down at the district court, and I've been having a lot of problems with the state of Michigan on this. They do one, but they don't do the other. And sometimes they get the guy to waive it. Sometimes they just don't do it. In this case, I don't know the reason why, but I definitely need a evaluation as to criminal responsibility. And after that, I'm going to have some independence done on both competency and criminal responsibility. So I think we're going to need some time on this, but I just want to make sure I get it the order. In fact, Judge Shadler said she was going to put it in again, but just to cover myself, I'd ask Your Honor to put in an ordering evaluation.
So I have an order dated September 13th of 2022 for evaluation regarding criminal responsibility.
Yep.
So
that was never done.
well, I understand that, but I don't think I need to order it again. I think you just need to send it again to the forensic center.
I can do that, Your Honor, but I've been having not very good luck.
We haven't up here either, to be honest with you, but so I mean, we have that order in place, so I would say just it's already ordered, so
Does everyone have the
just
letter dated October 31st?
Okay, what does that say?
It just says there will be additional delays in scheduling the criminal responsibility evaluation because of the high volume of evaluation orders received by the center. Please know that the evaluation of the defendant's criminal responsibility will be performed as soon as possible. If you have any questions regarding the continued delay, then it gives a telephone number and email address.
Can you send that letter over to me? I apparently didn't get that.
Yeah.
all right. I don't have that in the file as well. It might be in the district court file.
Yeah, that's what I'm guessing, because it's titled to Judge Shadler. So I can send it to, you want me to send it to Ms. Adams?
Yes, please, and Mr. Glazier. And
Yeah.
I'll set this out for another pre-trial. Let's do February 15th, just to see if we've heard anything. How's that, Mr. Glazier?
That's fine, Your Honor.
And that'll be at 8:30. I used to volunteer there, and they used to have a full staff of people that did these, and that was back, John, when we always got them right away, and then they went to part-timers and contract employees, and they're understaffed, and it's a mess. All right, so Mr. Dietos, we will see you back here on February 15th at 8:30 in the morning for a pre-trial, all right?
Unmute. See? That's why I don't mute. While we're going through this, watch his appearance change. So after each hearing, they put a note in the docket that says the hearing was conducted, who was there, and if there's anything special that happens. And it just says, okay, when your next appearance is. So 2015 or 2/15/23. So we're from December 20
Sir, what is your name,
to
please?
23.
First name is Chris, last name is Dietos.
Right, so hold on, Mr. Dietos. This is Mr. Glazier. So, and I'm waiting, oh, I got Miss Blaze. Forgot you were still there, Miss Blaze.
I had to turn up
All
my
right.
volume. I can't hear anything.
Can you hear me now? Miss Weiss, can you hear us now?
Yes.
I wonder how
Sorry
many
about that.
years Mr.
Not a
Glaze has
problem.
been doing this.
So this is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of the defendant, and I have Jacqueline Weiss appearing on behalf of the people. This is the time set for a first pretrial conference in this matter. Mr. Glazier, how do you wish to proceed? You're muted, Mr. Glazier.
Sorry about that. I just got last week a criminal responsibility ruling by the Health and Human Services. I need to have an independent done.
Well, hold on a second, hold on. Did we place the criminal responsibility on the record? And the, or the
That's not one you would put on the record. The competency had been put on the record well before. We just didn't have the criminal responsibility.
Okay. So you have that now.
Yes.
And so you're going to have an independent done.
I'm going to have an independent done for criminal responsibility as well as ability, his ability to assist me at trial. We have a person we use. I don't know if I need an order, but I'll have an order prepared if Your Honor doesn't mind. And I'll put in the name of the person we use.
Do you have a
All
time?
right.
I'm here.
Ms. Weiss, what did you say?
I just asked him if he had a time frame, like how long. I have no objection, obviously, to him getting an independent. I was just wondering if we have a time frame, looking out how far your guys doing it.
Independent are usually shorter than the state ones, which can take a year. So.
I've got to get a hold of the person. So I don't know. Maybe.
So what I suggested be a May 3rd pre-trial, and if you need to adjourn it, you guys can just stick to adjourn it.
Okay.
Okay.
And Mr. Dietos, I got your letter. I will set up a Zoom conference to speak with you next week.
Can I speak to you in a breakout room real quick? I have something I'd like to speak to you about.
Yeah, I don't have a problem. If you can't, Judge, that's fine. I'm going to talk to you next week, Mr. Dietos.
But can I give you my mother's phone number? She'd like to speak to you.
Yeah.
So hold on, everybody, hold on. So we are live on YouTube. So Mr. Dietos, I don't want any phone numbers being placed on the record. So
all right.
you just tell your mother to call Mr. Glazier, all right?
She doesn't have his number. That's why I had to give her.
You do on all your paperwork has the public defender's office.
Okay.
Or if she can't find it, have her call the courthouse and get the public defender number, all right?
All right.
Okay, so, all right, so we will set this out to May 3rd at 8:30 in the morning, and then Mr. Glazier, you can do the step in order to adjourn.
Yeah, I'll do that too, Your Honor.
Okay, and then I'll sign the order upon presentation.
May 3rd at what time?
8:30. All right, you're all set, Mr. Dietos. You have a good day.
So I don't know if you caught it, but they said that he had already had his competency evaluation and he was found competent to stand trial. Then they did a separate evaluation, which was his criminal responsibility, and it was the states which found him okay to stand trial. So then they had to go, and he's going to get an independent one. The reason I put all of these in there is because I think it's super interesting to see how many times they go back and forth to trial, checking in and saying, okay, I'm waiting for this. Okay, I'm waiting for that. Okay, I'm waiting for this. And so many times. And it's very redundant and it seems very inefficient. Thank you, guys. You're the best. You're the best. Absolutely the best. You guys make sure you check out Credence and Mikey. They have a great show.
Matter of
We'll
the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Dietos. I have Jack Weiss appearing on behalf of the people. I have a March, let me see here, a March 22nd letter, 21 letter from you, Mr. Glazier, stating we have not yet received the criminal responsibility report. We still have it?
I don't know, Your Honor. I think I've received it since I sent that letter out.
We actually received that like January 31st. We had a hearing February 2nd, and on February 2nd, you asked for an independent examination.
This is one of the first ones I saw, and it really worried me. Like, this is a murder trial. You should know this.
Okay. I didn't have the original though when I looked in my file, so they sent it to me. I think I got it since that time.
Okay.
I think we got the original one that was done by the CFP, but have you gotten a report from your independent?
No, Your Honor, I need, what I really need is about a week to go down and talk to Mr. Dietos in person, if the court will allow me to.
Okay, so I don't have, all right, I can set it for May 10th. Is that all right?
Yeah, that's fine, Your Honor.
All right, so Mr. Dietos, I am going to set your pretrial over to May 10th at 8:30 in the morning. And Mr. Glazier, can you do the stip in order to adjourn?
Yes, I can, Your Honor.
All right, so Mr. Dietos, I will see you back here on May 10th at 8:30 in the morning, all right?
No trial. We don't get to trial. And just so you know, the reason Penny has to, slum it in the unicorn bed is because my son took the other brown neutral bed into his room to babysit Ziggy the other day when I had to take Penny to the vet because Ziggy had an absolute meltdown because he couldn't see me. I wasn't in the line of sight. Oh my gosh. The world's ending because I've spoiled my dogs to the point that I can't be out of their sight. It's terrible. So the thing that concerns me is, did Mr. Glazier order the independent eval, or did he totally forget? Now he says he needs to go talk to him about what? I'm not sure. If you need to go back, just rewind back to the start of where I start playing the video. The rest of it's just me babbling. Thank you so much.
Your Honor.
Yeah.
On Dietos, there, I talked to Jackie last night kind of late, and so I haven't had a chance. She says she has a pretrial on Friday. Could we adjourn this over to the same day as that?
It was last night.
She says who has a pretrial?
She said she has a pretrial in front of you on Friday. And because I told her I needed to adjourn it like a day or two. And she asked, or I was wondering if we could adjourn it to the same day as her other pretrial.
Sure. Miss Adams, do I have a criminal pretrial on Friday?
Judge, I can jump in. We set Christopher Mauer for Friday at 11.
Do you want me to set this one at the same time?
Yes, please.
Yes, Your Honor.
All right, so Miss Adams, okay, so we won't take Mr. Dietos this morning. We'll set them for a pretrial on 5/12 at 11. Okay, thank you.
Thank you very much,
All right.
Your Honor.
You're welcome. Okay.
And another one. So then they set it for 5/12. That hearing didn't happen. There was no docket for that date for some reason. So then it was reset for 5/3. And then I can't find any evidence of that happening. There's no video and there's no notes in the file. So then we go all the way forward to June 7th. For some reason, I don't know. I couldn't figure out.
People of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180 FC. I have John Glazier appearing on behalf of Mr. Dietos, and I have Jacqueline Weiss appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Hold on 1 second.
Real quick, you said something about the blue wall. Doesn't that look like asbestos behind the jail? Like that wall? It really creeps me out. I don't know what it's made of.
Breakout rooms. Some people it's looking at me. Okay. Mr. Glazier, how would you like to proceed on behalf of Mr. Dietos?
Yes,
Your
Your Honor.
He's got his hand raised, Your Honor. Maybe he wants to talk with me.
Can I talk to my attorney in a breakout room real quick?
Yeah, so that's why I was asking Mr. Glazier. So Mr. Glazier, I'm gonna put you guys in a breakout room.
All right.
And there we go. I'm gonna open those rooms. Right, we're back on the record. So Mr. Glazier, if you had a moment to speak with Mr. Dietos.
I have, Your Honor. I've also spoke with the prosecutor, Ms. Weiss. Your Honor, I talked with Mr. Dietos at length yesterday down at the jail, and I thought we were going to ask to adjourn this out quite a while. He's had a change of heart since I talked to him, and I think we're probably going to work out a plea. The only thing I would ask is maybe we could adjourn it till next week, and Ms. Weiss and I, part of the plea would be a killability to the guidelines. I want to see if we can agree what the guidelines are.
Okay, hold on a second. $15, $14, $15. Yeah, I can set this out to June 14th. So, Mr. Dietos, I will set your pretrial over to June 14 of 23 at 8:30 in the morning. Mr. Glazier will run your guidelines and have a conversation with Ms. Weiss in hopes that this can be resolved. So, Mr. Glazier, you'll do the stip in order to adjourn?
Yeah, I can do that, Your Honor.
All right, very good. Mr. Dietos, thank you, and I'll see you back next Wednesday.
So now we're back 1 week later.
All right, so Mr. Dietos, you want to go up to the podium?
And this is where things get a little interesting. And how does the school still have asbestos in this day and age? I remember when I was in high school, like 100 years ago, it had asbestos and they like vented it out into the walkway. So when we walked by it, we got like shot in the face with this negative pressure asbestos air. It was great.
Your Honor, could I ask, this might take some time. Could my client do it from the chair?
No. You can sit, he can stand.
All right.
You don't have to stand.
Okay, that's fine.
Really?
All right, yeah, I just need him at the podium, not you. All right, so Mr. Dietos, okay, so this is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180 FC. I have John Glazier appearing on behalf of Mr. Dietos, and I have Jacqueline Weiss appearing on behalf of the people. It's because my court reporter faces you all this way to do a record, so it's easier for her if you're all there. All right, so Mr. Glazier, this is a date and time set for a pretrial. I received an amended felony information. Count 1, child abuse first degree. Count 2, homicide, open murder, and count 3, homicide, manslaughter. So, Mr. Glazier, how do you wish to proceed today?
Your Honor, we intend on entering a plea to count 1, the child abuse first degree, and to count 3, the manslaughter, with the understanding that count 2 would be dismissed at the time of sentence.
Right, is that a correct recitation of the plea, Ms. Weiss?
That's correct, Your Honor.
All right, so Mr. Dietos, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
So I don't know if you noticed, but Penny
You
just
speak
stole
your full name,
Ziggy's phone. I
Christopher
hit
Nicholas
hers.
Dietos.
All right, so Mr. Dietos, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, child abuse first degree, which carries a maximum penalty of life or any term of years, as well as count 3, homicide manslaughter, which carries a maximum penalty of up to 15 years in prison and or a $7,500 fine? So is it your intention to plead guilty to both of those counts?
Yes, ma'am.
Okay. Are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, ma'am.
Okay. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct.
And Ms. Weiss?
That's correct, Your Honor.
And
No,
Mr. D?
Your Honor, it's not correct. Actually, and I forgot to put this on, the prosecutor and I have had a discussion, and there would be a killable plea, Your Honor, that the sentence would be within the guidelines. And the prosecutor and I agree that the guidelines work out to be 11.8 years to 18.75. Is that right?
Yeah, I got 135 months to 225 months.
Yeah. And that the maximum would be a term of years to be determined by the court, not a life sentence on it.
All right, so you guys are stipulating that the guidelines are 135 to 225, that he will not be given a sentence of life, that he will be sentenced to a term of years. And
That's it.
that's it. There's not a kilogram that he would be sentenced within the guidelines, no.
Oh, yeah,
The bottom-
it is within the guidelines.
Within the bottom end would be within the guidelines, and then the top end, whatever the court determines.
Okay, so the sentence would be, okay. So anywhere from 135 months to a maximum of 225.
No,
Right.
No,
on the bottom end, yes, so it's, yes, but you could do whatever on the top.
Top end, you can do it, whatever, just it wouldn't be life.
I need bigger postage. Here's the little one, bigger one. Okay, so we.
80%.
So the plea would be the low end of the guidelines to whatever,
Term of years.
okay. So the 135,
No, it's
No,
not, it's not.
It's
to
not the low
of
end,
the
it's
guidelines.
anywhere which,
Okay.
35 to
Within the
225 to whatever.
Like 20 of them at once. Apparently, the plea agreement was very confusing, but this whole thing is about to get way more confusing, which is why I showed you the very first thing that I showed you.
okay.
Hey,
So,
howdy.
Mr. Dietos, do you understand that's part of the agreement too?
Yes.
Anything else, Mr. Glazier or Ms. Weiss?
No, you're right.
No, you're right.
So other than that, though, Mr. Dietos, neither the prosecutor, the defendant, nor anyone on your behalf has discussed any other possible sentence with the court. Is that correct? Some treatment, whatever. Okay. Would you agree with that, Ms. Weiss and Mr. Glazier?
Yes, sure.
Yes, Your Honor.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would have been otherwise appealable had you been convicted at trial? Do you understand that?
Mhm.
Do you understand that any appeal from the sentence and conviction, from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
That's that.
So if you had been convicted at trial, you would have had an automatic right to appeal. But because you're entering a plea, you don't have an automatic right to appeal. You would have to file paperwork for leave to appeal, and they would have to decide whether they would grant that or not. Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? All right. So Mr. Dietos, how do you wish to plead to the charge that on or about September 1 of 2021 in the village of Blissfield in the county of Lenawee, that you did commit the offense of child abuse first degree, guilty or not guilty?
Guilty.
And how do you wish to plead to the charge that on September 1 of 2021 in the village of Blissfield in the county of Lenawee, that you did commit the offense of homicide manslaughter, guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what was placed on the record? Is the prosecutor or defense counsel aware of any other promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, you're.
And Ms. Weiss?
No, Your Honor.
Has your attorney, I mean, we put your basic sentence on the record, but other than that, has your attorney promised you any particular sentence or estimate what your sentence will be other than the agreement? Like treatment in prison or fines and costs or anything?
No.
All right, would you agree with that, Mr. Glazier?
I would.
Right, and is it your own choice to plead guilty to these charges? All right, so, Mr. Dietos, on September 1 of,
Can I ask if there's?
You wanna-
I
you
want
can
to
do
put
it.
on the record, then I could ask the factual basis after that.
that's fine, Ms. Weiss, any objection to that?
No, Your Honor.
All right,
Your Honor, for various reasons, I wanted to engage Mr. Dietos with some question and answer before I go to the factual basis. Mr. Dietos, you're aware that we had a criminal responsibility and a criminal competency exam done by the state of Michigan, is that correct?
Yes.
And you participated in that,
Yes.
and that took place for several hours. Was it 1 day or 2 days?
1 day, I think.
Okay, and you are aware that you were found to be criminally responsible by the state of Michigan psych unit, as well as Township. You understand that that was their basis, and you've seen those reports. Is that true?
I think so.
You don't think that was what the report said?
Oh, yes, I do. I'm sorry.
You and I met back just last weekend, June the 6th, and we spent an hour or so going over various documents and forms and jury instructions, et cetera. Is that correct? You gotta say yes or no, because you're being recorded.
Yes.
All right. One of my concerns, and actually I knew this before the reports were done, was your father indicated you had a very low IQ. Is that true?
Yes.
And in fact, some of the documents that were presented to the state of Michigan shows that your IQ was actually, when you were 7 years old, the test reflected it was 51. 51, was that correct?
Correct.
And you understand that's very low.
Yes.
All right. Now, your father, who passed away
Yes.
while this is proceeding, advised me that you are quite capable of understanding things and communicating and expressing yourself. Is that true?
Yes.
I would also place on the record that I find him to be very capable of communication and understanding what I've been trying to tell him.
just to put that into perspective a little bit, an IQ of 50 to 69 in adults is a mental age from 9 to 12 years old. So a 9 to 12-year-old is capable of understanding right from wrong and doing things are not right, but they're probably have a lot of difficulty understanding the complexity of these court hearings. So try and take that and look back at what we've seen so far and imagine a 9 to 12-year-old sitting in this hearing compared to this gentleman.
Okay. When I went down to the jail last week, I presented to you a plea bargain that was offered by the prosecutor. Is that correct?
Yes.
And in fact, it's the plea bargain that we put on the record here today. Is that true?
Yes.
And you understand that, and I didn't write down the exact months, but your minimum sentence is going to be determined by the judge. You understand that?
Yes.
And that will be within the guidelines.
Yes.
You understand that? And the prosecutor and I have them at, what is it again, month less?
Any age.
135 to 225 months.
That your minimum sentence will be between those months. Do you understand that?
Yes.
That is roughly 11.8 years to 18.75, I believe. You understand that?
Yes.
That means when you come back for sentencing, the judge is going to set a minimum sentence that is somewhere between those. Do you understand that?
Yes.
So the earliest you would be, that's when you're eligible for parole. It's when you have served your minimum sentence. You understand that?
Yes.
So at the very earliest that you would be eligible for parole is going to be approximately 11.8 years. You understand that? Minus whatever time
Is
you
that
served.
like 12 or so? Or?
Almost 12. But the judge could go up as high as almost 19, 18.75 years. You understand that?
Yes.
That's just your minimum
Standing
sentence.
now.
That's where you become eligible for parole. You understand that?
Yes.
The maximum sentence on this could be up to life, but we have agreed it'll be a term of years. You understand that?
Yes.
What that means is that if they don't grant you parole the first time, second time, third time, the fourth time, there's going to be a maximum that you could serve if you don't make parole. You understand that?
Kind of.
Okay, you're going to have to serve at least a minimum of, let's say the judge picked 12 years. That means you're going to have to serve at least 12 years, at which time you'll become eligible for parole. You understand that?
Yes.
You'd apply for parole, you'd have a parole hearing. If you were granted parole, you would get out on parole following the hearing. You understand that?
Yes.
Now, they could deny your parole, which is called flopping. You've heard them say flop. That's basically being flopped, and then you become eligible for parole again. And it's not a homicide, so I'm not sure what it is, but it's at least every 5 years. It might be quicker than that. And so then you'd apply again in 5 years, get parole, you're out. If you don't, keep going. If it went all the way up to the maximum, they'd have to release you. We don't know what the maximum is because the judge is going to set that when you get sentenced. You understand that?
Yes.
I asked her and we agreed that it would not be a life offense. My sole reasoning behind that is I know the parole board on second-degree murders where it is a life offense are less likely to parole you. And so I didn't want anything that said life offense as the maximum. You understand that?
Yes.
So to summarize, you're going to get a minimum sentence between almost 12 or to a little less than 19. That's going to be your minimum. And your maximum is going to be a term of years that the judge is going to set. Okay?
Yes.
You understand that?
Yes.
Now, when I talked to you at the jail, and I also talked to you here today, I advised you that I could get an independent evaluation done as to your competency and your criminal responsibility. Is that true?
Yes.
And you understand that would not be
Not
by
ready.
somebody from the state of Michigan, that would be by somebody that I choose that I would hire.
Correct.
And they would reevaluate your competency to stand trial as well as your criminal responsibility to stand. Do you understand that?
Yes.
Regardless of what those findings are, you would have a right to a trial. Do you understand that?
Yes.
And if my independent evaluator said, hey, you weren't criminally responsible, or you weren't competent, that would be an issue that would, or criminally responsible, excuse me, that would be an issue raised at trial. Do you understand that?
What does that mean? Like,
That means if we went to trial, you could present, it's sometimes referred to as an insanity defense. But that because of a mental illness, you don't appreciate the wrongfulness of your acts, basically. And it'd be a fight between the state of Michigan and our expert, if he deemed you to be not responsible, as to whether you're not guilty by reason of insanity. Do you understand that?
yes.
But likewise, the jury could still find you responsible and find you guilty of child abuse first and open murder. Do you understand that? First degree murder.
Yes.
And you're choosing not to have that evaluation. In fact, I told you that's what we were gonna do, and you told me, I think last week and again today, that you don't want to have those evaluations done. You want to proceed with the plea record. Is that correct?
Yes.
All right. So just so you understand, and I want to make sure you understand this, and it's kind of tricky. You're charged with open murder, but there's a charge that is referred to as felony murder. I've explained that to you.
Yes.
Okay. Basically, what felony murder says is that if you commit a murder, or if someone dies by your acts during another crime, and the crimes are listed within the statute, that you are guilty of first degree murder, could be found guilty of first degree murder. Do you understand that?
Yes.
Right, and I've explained to you that one of those crimes is child abuse in the first degree. Do you understand that?
Yes.
So if you went to trial and a jury found you guilty of child abuse in the first degree, they could find you guilty of felony murder, which is first degree murder. You understand that?
Yes.
And first degree murder carries life without parole. I've explained that to you.
Yes.
So that's the risk for you, is if they find you guilty, if a jury found you guilty of child abuse in the first degree, they could find you guilty of felony murder, and you could face life without parole. You understand that?
Yes.
That's not to say they would, but that's what the risk is for you. You understand that?
Yes.
All right. Now, I've explained to you, child abuse in the first degree requires a jury to they don't have to show intent, but the prosecutor would have to show that you knowingly or intentionally, which would be intent, but knowingly cause physical harm to a child, serious physical harm to a child. Do you understand that?
Yes.
All right.
Okay, let's breathe for a minute. Number one, the judge had a chair. I saw the chair. I'll rewind and show you the chair if you're going to argue about the chair. I'm just saying. Like, the judge had a chair. She turned the camera off for a moment. She didn't seem like she had the chair the whole time. Perhaps it's like an elevated chair. It was a standy chair and she pushed it out of the way. I don't know, but she had a chair. Number two, so he didn't refuse the initial evaluation. He did have an evaluation. It proved he was competent, but that was an evaluation by the prosecutor and their people. The defense was looking to get a second evaluation, independent evaluation, the way each side gets their own experts to say what they want them to say, I guess, pretty much is the thing. As far as IQ goes, 70 and below is considered below average. And I think it's like 68% of people in the world fall between the 85 to 115 range. And 116 to 144 is considered above average, and 160 and above is considered genius, but 70 and below is considered low IQ. So an IQ of 50 is significantly below the cutoff for low IQ. Watch, she has a chair.
And you don't wish to take that risk and want to take the plea bargain at this time.
Yes.
Do you have any questions or of either the court itself at this time that need to be answered?
Not this time.
You understand everything that we've gone over, both at the jail and
She just sat
tried
down.
to put on the record here today?
Yes.
And you still want to proceed with this, please, is that correct?
Yes.
All right. I'm gonna ask you some questions about, on the amended information. You understand, I'm
Okay,
gonna
wait.
show it to you, but this homicide is gonna,
Got
open murder, which could be first degree murder, is gonna be dismissed at the time of sentence. All right, what you're pleading to is count 1, child abuse first degree, and count 3, homicide manslaughter. You understand that?
Yes.
All right.
Yeah, but there's some
We'll
drama.
go over a couple things. On September 1st of 2021, were you watching or taking care of your son?
Yes.
And that is Weston Diethos?
Yes.
And at that time, he was born on June 23rd of 2022, is that correct?
Yes.
So on that date.
Well, hold on a
Yeah,
second.
he couldn't have been born after the date of the offense.
The date of offense is September 1 of 21.
Did I say June 23rd?
You said 2020.
I think it was this
June
it was
23rd.
last year, the
June
23rd.
23rd, 2022 is what I meant to say.
Right, you keep saying 22. It's not, he couldn't have been 2022 because he had to have been born before the offense date, John.
Oh, okay, I didn't notice the offense date. Well, that's his date of birth.
What day was your child
Maybe
born?
your offense date's from.
June
Yeah.
23rd, last year.
2022, so
The-
the on or about, can I amend it to September 1st, 2022, so the information is incorrect?
Are you gonna amend that today?
Yes,
And we have no objection.
sorry, John.
So it's September 1 of 22.
Yes.
All right, we'll go back to Mr. Diethos, your son, Weston Diethos was born on
June 23rd.
June 23rd of 2022, is that right?
Yes.
So on the date of September 8th, or excuse me, September 1st,
The mother is in communication with the prosecutor. They discuss her later. She did not want to be named in the newspaper articles, and she doesn't want to be shown in court.
we got that date right, because the date of death says September 8th.
September 8th.
Thank you. I appreciate the support.
That date wrong also?
Yep, September 8th.
So we need to amend that to September 8th of 2022.
They're amending it incorrectly. They've got their dates all screwed up.
You all set?
I guess so. What are we doing?
It was the offense
Changing
date. not
the
the birth
date to honor about September 8th instead of September 1st.
So September 8 of 22?
Yes. Mr. Diethos, on September 8th of 2022, your son would have been about 2 months and a couple weeks old, is that correct?
Correct.
And you were caring for him at that time?
Yes.
And the mother was gone and you were the sole
caregiver.
providing the
She was at some kind of class that she had to take out in Adrian by the college.
All right. And the child became upset and was,
I had a mental breakdown.
I understand it. You understand that by pleading, you're giving up any type of defense, saying that a mental breakdown caused this, it caused you to have injure your child. You understand that? The child was being fussy or acting out, or it got you frazzled. Is that a fair statement?
What's frazzling?
Upset or
Yes.
nervous?
Yes.
Okay. And as a result of that, you grabbed your child and shook the child rather violently. is that correct?
Yes.
Now, you knew that shaking the child in that manner could cause serious physical injury, is that true? And as a result of that, your child eventually did die from being shaken, is that correct? Yes. It was. And this all occurred in Lenawee County here in the state of Michigan, is that true?
Yes.
You're absolutely sure this is the way you want to handle this thing today?
Yes.
I don't have any other questions.
Any other questions, Ms. Weiss?
At the time that you shook the child, you intended to shake the child to get it to stop crying?
I didn't want to. Yes. I didn't mean for him to pass away though.
And nothing further, Your Honor.
Ms. Weiss, could you also, when you do the amendment, correct the first name of the child in count 3?
Yes, and
Hey, Victoria.
I looked at the report and it looks like the death certificate listed date of death is September 8th, but it's all September 1st, 2022.
So the event occurred, but the death certificate was dated September 8th.
Yeah, the death certificate lists the date of death as, so
It's,
that may be in there.
that's from the coroner's office, yes, but the actual date is September 1st, 2022. So I'm gonna leave the September 1st date on
That's fine. I was just asking questions based.
No, no.
Yeah.
on
Okay.
date of
I
death.
understand. Okay,
Thank you so much, Carrie T.
Ms. Weiss, is there anything else you wanted to add to that or ask Mr. Dietos?
it. No, Your Honor.
Has court complied with MCR 6.302 B, C, and D?
Yes, Your Honor.
Yes, Shirley.
All right, and I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Mr. Glazier, I appreciate you going through all of that to make sure Mr. Dieto comprehends what he was entering into in the plea. So there is a Killebrew agreement to the sentencing range in a term of years. But other than that, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew. I'm going to refer this matter to the probation department for a pre-sentence investigation. Are you both available July 27th at 8:15?
I believe so, Your
Yes.
All right. So I'm going to set sentencing for July 27 at 8:15 in the morning. Mr. Glazier, would you like your client to appear in person?
Yes, I would, yeah. Did you say
8:15. I do 8:15. So, Mr. Dietos, I will set this matter for sentencing on July 27 at 8:15 in the morning. Now, someone from the Michigan Department of Corrections, a probation officer, is going to come speak with you over at the jail. When you meet with him, be truthful about your background, be truthful about the events that occurred.
That led up to what happened.
Just
not every?
talk about your background, be truthful. They'll ask you a bunch of questions. So be honest when you talk to them. They'll ask you about what occurred, be honest about what occurred. They'll prepare a report. We'll get a copy of that report to Mr. Glazier. Mr. Glazier will meet with you beforehand and review that with you.
Or he's
And then
over
you'll
work.
come in front of the court that day for sentencing in person, okay? Mr. Glazier, any other?
Your Honor, the only thing I don't know if the court would want the probation, or at least the court, I'm going to ask you to consider is maybe some mental records and the evaluations. I can provide those.
You can provide those to Ms. Weiss for his mental
I
health
think she has
background.
probably the same ones I do, but I will.
I mean, the probation department will always seek those medical records, so, and that information for the PSI, so you can provide that to the Michigan Department of Corrections if you would like, Mr. Commissioner.
All right.
All right, is there anything else we need to address on the record today with Mr. Dietos?
No, thank you.
No, Your Honor, thank you.
Okay, so Mr. Dietos, we will see you back on July 27 at 8:15 in person. Thank you.
Here's what you wanted. This is where we're at.
So where I kind of get hung up on this one is his IQ. We know what his IQ is. We just talked about it. Most people are taught not to shake a baby through, I'm not even sure how we're taught it. I mean, we know it, we've seen it, we've heard it, but has someone of his IQ processed that to understand what it was? Like, not to do that, and what will happen if you do that? Because yes, they did a criminal responsibility, understanding, you know, what you did and that it's wrong, but really? Does he really? I don't know. But he's taking a plea instead of potentially fighting it. So, you know, it is what it is and it's his choice. So I threw this in here because, like I said, I've been going through the docket, and I know some of you don't like to look at the docket because it gets really confusing and things like that. But what I wanted to show you is in Michigan, there's 2 buttons on top of where it says events. And when you hit one of them, it puts everything into a chart under the date. And it seems like there's a lot of information, but if you really look at it, they're duplicating everything under the first cell there, because you can only put so many words in each field. So they have to keep, it kind of just bleeds over. So if you look, all the information underneath is the same, except for where the arrows are pointing. And those 2 things are different. So if we keep playing, this is what it actually says. It says in person, who was there, and that he pled guilty to count 1 and count 3 because they dropped the count 2 of open murder and they added a count 3 of homicide manslaughter. And so other charges to be dismissed, which was the count 2. The Killebrew to sentence within the guidelines. So the bottom end of the sentencing range would be within the guidelines that they discussed, and then the top end would be up to the judge. And then Public Defender Glazer went step by step over the agreement on the record with the defendant to make sure he understood. And that was mainly to protect against appeals down the road. Sorry, weird noises from dogs. So his sentencing date is going to be 7/27, and like I said, there's more drama coming. But I wanted to go over the Killebrew agreement because these are unique to Michigan. There's the Cobbs and the Killebrew, and we've heard both of them talked about. There's judges like Judge Simpson who refuses to accept a Cobbs agreement. We've heard lawyers mention that many times. I know you don't take Cobbs agreements, but... And so the difference between the 2 is with a Cobbs agreement, you're basically negotiating the sentence with the judge before the plea is entered and saying, hey, you know, Judge Simpson, for example, we want this. Will you agree to sentence him this before it goes through? With the Killebrew agreement, the defense and the prosecution negotiate out the sentence. The defendant enters the plea agreement, and then the judge sentences whatever they want. At that point, the defendant has the opportunity to withdraw their plea if the judge does not follow those guidelines that were negotiated prior to the plea being entered. So that's the difference between the 2, if anybody cares. I wanted to know what the words meant because I kept hearing it, and I thought they kept saying Killebrew. So this is the week later when it's supposed to be sentencing, but of course that didn't happen.
First one she sent.
Jail, waiting rooms. Okay. All right, this is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180F.
Sorry, I just wanted to add real quick. You threw that when you're pregnant, you find out all the information A to Z on babies. You get it from your doctor, you get it from things like that. But he wasn't married to the mother. And if he didn't go to any of those appointments, he didn't receive any of those trainings, would he know that? That was kind of the thing that was going through my head when I was watching this is, did he know better before he performed the action? Should he have? Probably. Like a normal person, absolutely. But someone with an IQ that low, I don't know. It made me think.
C, I have John Glazier appearing on behalf of Mr. Dietos, and I have Jacqueline Weiss and Douglas Hartung appearing on behalf of the people. So this is a date and time set for two things, actually. One is a motion to withdraw a guilty plea that was filed at the court on June 21st. And I do have the response that was filed by the people. And then it's also the date and time scheduled for sentencing in this matter. Mr. Glazier, I presume you'd like to address the motion to withdraw the guilty plea first.
Your Honor, I've spoken with my client.
Can you stand at the podium?
It's hard for me, but I can't.
Okay, that's fine.
Your Honor, my client got a hold of me after the motion was filed, and he asked to withdraw the motion. And I want to make sure that this is something he's willing to do.
Mr. Dietos, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you state your full name for me?
Christopher Nicholas Dietos.
All right, Mr. Glazier, do you wish to inquire before me?
Yes, sir. Mr. Dietos, we were in here and entered a plea on this charge. I forget the exact date. What date was the plea?
Looks like we pled on June 14th.
On June 14th. Do you remember being in court when that occurred?
Yes.
And I asked you a long series of questions. I think it probably took 10, 15, 20 minutes where we discussed your options, the plea offer that's been made to you. Some of those options included having our own independent evaluation and adjourning us out, getting that evaluation done and go from there. Did you, is that correct?
Yes.
And you understood that? You still understand?
Yes.
You understand that if we proceed with this motion and the judge grants the motion to withdraw, that we could still be able to do that. We would have a independent evaluation done. And if the judge didn't set aside your plea, we could always appeal that decision. You understand that?
What's that?
That means if we asked, we filed a motion to have this plea withdrawn, the prosecutor's objecting to it. And I don't know the reason. Well, I guess I know the reasons why, but I don't agree with their reason. But if we went through with the motion and the judge denied it, she sided with the prosecutor, said, no, you can't withdraw your plea. You understand we could appeal that decision, and the Court of Appeals could very likely allow you to withdraw your plea. You understand?
That means get it back.
I'm sorry, sir, you'll have to speak up.
That means get it back.
Take it back. That's right.
Yes, I understand.
And you don't want to do that.
I do want to take it back, yes.
Oh, excuse me. You do want to take the plea back.
Yes.
Okay. I'm just saying, you understand that if the judge denied your motion here today and we didn't withdraw it, that you could appeal that decision of her not granting you your motion. Okay? And you don't.
I can't hear him and neither can my court reporter, so we can't make, maybe you can sit, but Mr. Dietos, okay. Could you re-ask that question?
Yeah. You understand that if we proceeded with this motion, and let me ask the way I did originally, and the judge granted it, we could then do that independent evaluation and proceed from there, have a trial or whatever we could do from there. You understand that?
Yes.
Now, if the judge were to deny that motion and the prosecutor is objecting to it, you would have a right to appeal that decision by the judge. In other words, that she wouldn't let you set aside your plea. You would still be able to appeal that decision. You understand that?
Yes.
And you don't wish to do either of those things at this time, is that correct?
Right, I would like to continue
I'm
with
sorry.
sentencing.
Wait, no, could you speak up?
Yes, I would like to continue with sentencing.
Okay.
Wait, what?
Is there, let me ask you this, why did you make that, you made that request the same day that you took the plea? At least that's when your letter was dated to me. What caused you to file that letter to ask to have your plea set aside, you know?
I was underneath a lot of stress and I realized.
You gotta, all right, so
I
Mr.
really-
Gatos, why don't we do this? You go stand at the podium, because you're very soft spoken.
Okay.
So it's not, but Mr. Glazier, let him answer your questions.
Why did you send me that letter requesting that?
I was underneath a lot of stress and I didn't make the right decision after the fact. I knew I screwed up and I wanted to plead the whole entire time. I wasn't, just a whole bunch of stuff was going through my head.
Okay, were you getting advice from people in the jail?
They came right up to my door and started, and it got me overwhelmed, and that's when I made the wrong decision and sent, and that letter went through. And I didn't, and after the fact, I lost the opportunity to get the letter back, and that's where I'm at right now. But I do
When
want
I say people, we're not talking about,
multiple people, no.
not people that work at the jail, you're talking about inmates, other
Yes.
inmates, is that correct?
Yes,
And you feel comfortable withdrawing your motion to set aside this plea and proceed to sentencing today, is that correct?
yes,
I don't,
Okay, all right, so Mr. Gatos, you're asking that the motion to withdraw your guilty plea be withdrawn.
that means take it back, correct?
Well, okay, so you had asked your attorney to file a motion to withdraw the plea that you entered on June 14th, correct?
Yes, Your Honor.
Okay, so do you want to continue to sentencing today, or do you want him to argue the motion to withdraw the plea?
I want to continue with sentencing today.
So you don't want to take your plea back?
Yes, if I
Quit
do want to
doing
take
it
my
two
plea back.
different ways.
Am I not understanding?
it's kind of tricky.
It's
He just said, I'm not understanding, which is getting super frustrating to me. But to address this, he had a competency evaluation and a criminal responsibility evaluation, both of which said he is capable of attending court and assisting in his defense. So Ziggy's pouting. Penny stole his bone. So now he's gonna cry. This happens every time.
kind of tricky. So we have a motion to withdraw. You pled guilty the last time we were here to child abuse first degree and homicide manslaughter, correct?
Yes.
Okay. And then you asked Mr. Glazier to file a motion to withdraw your plea. Do you understand that?
Yes, Your Honor.
Do you want me to hear that motion today?
I would like to take the plea back.
Okay, okay. All right, so Mr. Glazier, are you ready to argue?
I don't think he's still not saying it right.
Your Honor, Mr. Dietos, you want to cancel the withdrawal motion?
What is?
You want to cancel the motion to withdraw your plea, right?
Yes, I want to take my plea back. Basically.
You want
cancel
to go forward with your plea,
Yes,
and you want to have the judge sentence you today based upon the plea to the charges of child abuse first degree and the manslaughter charge.
yes,
This is your voluntary decision to do this.
yes. No one else but my.
No one's coerced you or put you in duress to make this decision today.
No.
We're satisfied, Your Honor.
Do you have any questions, Ms. Weiss?
No, Your Honor.
Okay. So you want to be sentenced today?
Yes.
Okay. All right, so
Your Honor, may I?
The whole problem was he was saying, I want to withdraw my plea, and what he was meaning was motion. So everything got all clustered up because they don't know how to speak in normal people terms because they've been doing this for so long. Good on the prosecutor guy, whoever he is, for jumping in and doing that.
So when we set the sentencing date, the mother of Weston got ahold of me. It's today's her birthday, and she said she couldn't emotionally handle it and asked me to move the date. And I was under the impression that we were just having a motion hearing, so I didn't need the request to move it. And I didn't hear from Mr. Glazier that he was going to withdraw the motion. So I'm requesting to move this date to give the mother the opportunity to appear at sentencing. If we can even adjourn it by a week, Your Honor.
Told you I got
is there
nothing.
anything else?
No, Your Honor, thank you.
All right, so Mr. Glazier, I can move this to next week if you'd like, if you have any objection.
My client just wants to do it as quickly as possible.
I understand that, but victims do have a right to speak. And because the motion was on,
Can we do it tomorrow?
If I can get a hold of her.
Ms. Adams, could I see the book for tomorrow?
Sure.
Judge, my client thinks there was a victim's impact statement too.
That-
We never received a copy.
There was the paperwork that he showed me stated that there was a victim impact statement sent to Brittany.
All right, do we have a victim impact statement?
You know, I think it's just the one from the crime victims unit. I can show it. I don't think you got attached. It was supposed to. I'll show it to you. It's just the notice of the amount they were requesting. You want to see it, Judge?
No, you can show it to Mr. Glazier first.
I didn't get one.
So I can set this over till tomorrow.
This vehicle, that's all. It wasn't from her. It just showed what they said.
Do you want to, so I can set this for tomorrow and then Miss,
Your Honor, my mother, I can't hear her, but I'm assuming she said she can't show up tomorrow, but if,
okay,
I mean,
so I can do it another day, hold on. So I can do Tuesday.
next week.
I'm not gonna do it today, so
How far you go?
we are live on YouTube. I mean, I don't know, but I can't, by law, victims have a right to appear.
All of
And
this.
because there was a motion to withdraw, the people thought that's all we were doing today. So I can do it. I can do it August 2nd at 1:30.
Is that a-
I don't know, Mr. Hartman just left. Is he checking on something or just leaving?
No, just left.
All right, what about August 2nd at 1:30? That, they're an hour and a half away, that gives them a little bit later to drive. Ms. Weiss?
Yes.
Okay, so we will,
Yes, the 2nd of August at 1:30.
yep, so I'm gonna set this over to August 2nd at 1:30 PM. And the motion to withdraw plea is withdrawn. So we will see you back August 2nd at 1:30, and that'll be in person. We're stepping across, there it is. So we'll make sure to note that that's in person. Okay, anything else we need to address today?
No, thank you, Your Honor. I appreciate that.
Thank you both.
Well, that was a bit of a shit show, wasn't it? So whenever I'm talking out loud, mine know that I'm either on YouTube or on FaceTime with someone because that's the only time I talk to anybody out loud. So they always run over and jump up to see who I'm talking to and if they can talk to, I guess they're bored. I don't know.
All right, Rhonda Underwood, I got lots of jail. I have a gentleman in an Under Armour t-shirt.
Well, that was not supposed to go that long. I apologize. I did something wrong clipping that one. All right, bear with me. I didn't take the excess off of this. All right, there we go. Okay, so this is the sentencing. This is the one I initially saw. And the way Glazier talks about his client being, we would say low IQ. He uses some other words, and that's what kind of got me like, what? And then I started thinking about it and wondering, why this was going with the sentence that it was. So that's why I watched it from the
And
beginning.
Allison Arnold appearing on behalf of the people. So this is a date and time set for sentencing. The last time you were here, Mr. Glazier, your client had, after you very thoroughly questioned him on the record, asked to withdraw his motion to withdraw his plea.
That's correct, yeah.
Okay, so, and Mr. Dietos, and you have discussed that further, and
I have.
Worse.
I just would indicate for the record, Your Honor, and I was here the last time, his mother was here, and I had never spoken to her. She asked me out in the hall.
We'd waive the reading of that.
See, I told you. What did I just say? At least I haven't clicked the wrong button and flipped it back to the start. And what do? Click it back to the start, and it's all Biggin's fault because, I had to stop to say hi to Biggin. I just want to take a moment and thank Biggin again. I did at the beginning, but, he wasn't here at the beginning. There is absolutely no way I would have succeeded in this world without Biggin. I drove him absolutely nuts when I first started, asking him a million questions about absolutely everything because I'm neurotic like that. And he was patient with me and he answered them and he shared his people with me. Good, because I feel not very smart every time I do it. But I keep doing it because, consistency. But there's no way I would have survived without Biggin. I would have quit. He still answers my questions. He's a lifesaver. He's a sweetheart. And I'm sure all of you are subscribed to his channel. But if you're not, you absolutely have to because he is 1,000 times better than I could ever hope to be and does an amazing job. So thank you. Sincerely, thank you. You are amazing. And I appreciate you.
Do not have it with me.
you don't need it with you, but you did receive a copy to review, correct?
Correct.
All right, and did you have an opportunity to read and review that and discuss it with Mr. Glazier?
Last week, right?
Yeah.
Last week, yes.
Yeah, so I think you actually were back in a room and Mr. Glazier talked to you about it?
Yes.
Okay, and do you feel he answered any questions that you might have had?
Yes.
And you thoroughly understand the pre-sentence report, and what it contains?
To my best ability, yes.
Okay. Do you have any further questions about the pre-sentence report?
What she was asking is it accurate? You've read through it.
I've went over that by more than 5 times sitting.
Oh, good.
Is there anything glaringly wrong or anything you noticed that
It was
was
like striking kind of weird.
yeah,
No,
Yeah,
no, I mean,
other than recommendations, is there anything you disagree with?
no.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes.
Okay. Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, my client says it's accurate.
Ms. Arnold?
Judge, not with the report itself. I did go over the offense variables and
I haven't gotten there yet. So
Oh,
give me
yeah,
just a
okay.
minute. Okay.
I don't know your routine yet.
Okay. Does the pre-sentence report disclose any prior convictions, Mr. Glazier, in which there exists any constitutional defect? I show he has no prior convictions.
I don't think he has a criminal history at all.
All right, now we'll go to the guidelines. So I have received today guidelines, a new SIR. So let's see here. So originally, the guidelines I had, check this. The original guidelines that came with the pre-sentence report for the child abuse charge, the original sentencing guidelines were 29 to 57 months. And on the homicide manslaughter charge, the guidelines originally computed were 135 to 225.
Just you've got that flipped. The child abuse first degree is the A felony, that's the higher.
Oh, okay. All right, let's see. I wrote it in the wrong place then, probably 29 to 57 on homicide. Yep, and 135 to 225 on the child abuse.
So I don't know if you guys caught that, but the child abuse first degree is a higher sentence than the manslaughter. So we talked about the Killebrew agreement. So she has to sentence the low end of her sentence within those guidelines that were provided by probation in the pre-sentence report. But the high end, she can do whatever she wants with.
Now, I received an updated SIR from Ms. Holly today. And on this one, on the homicide manslaughter, the guidelines are calculated to be 19 to 38. And then the guidelines on the child abuse first degree were calculated at 135 to 225. I do have in my file that the prosecutor and the defense attorney at the time before the plea had computed the guidelines to be 135 to 225. So with regard to these guidelines, Mr. Glazier, do you dispute any of the PRVs or OBs?
Your Honor, I want to put a general complaint on the record is what I want to do. I was set and then, excuse me, she turned my phone down in the court.
Yes, you all go subscribe to Big N while Mr. Glazier turns his cell phone off.
I was given this by the probation department about 15 minutes ago and said, well, don't worry about it. It keeps the guidelines the same and it really does, it just changes a few things.
I have time if the three of us want to go back and go over the guidelines real quick.
That's not the point, Your Honor. The point is, if they're gonna do that, I just wish they would give me some notice. I've talked with my client and I said, I probably could have adjourned this and come back for a sentencing. We've already adjourned it once for the victim to be here, and that's why we're here today, for the mother of the victim to be here today. I gotta believe that the scoring probably does benefit my client a little bit, although I don't remember what OV7 is or OV7.
I seriously, 5 minutes in the back room, we can go through these guidelines and resolve. I don't want any outstanding issues hanging.
I just put on record, Your Honor, I asked my client if he wanted to adjourn so I could spend more time on these. And he said, no, he wanted to proceed.
So Ms. Arnold, Mr. Glazier, and Ms. Holly, you guys go that way into the jury room. I'm gonna get my updated sentencing guidelines book and I will be right back there with you.
I feel like they should have taken care of this before this hearing. Think about how many hearings that they've had. And it's nothing gets done between the physical time that they're in court. Oh, I might have forgot to edit this one out too. What you should have talked about the guidelines. It takes 2 minutes to have a conversation and make sure you're on the same page, and yet they didn't. And they come to court, and it has to be this big cluster. I don't understand. All right. Oh, it doesn't show. Okay, come on. There we go.
Thorough conversation with Mr. Glazier, Ms. Arnold, as well as Ms. Holly from the Michigan Department of Corrections, and we reviewed the changes from the original guidelines to the ones that were provided today or today. And Mr. Glazier, would you agree at this time that these guidelines are scored correctly?
The new ones, yeah.
Yes.
Yes, yeah.
Okay, very good. So, all right. So we have no one that wants to speak today. So Mr. Glazier, is there anything you'd like to say on behalf of Mr. Diaz? Other than Ms. Arnold, I'll give you an opportunity at the end, but you did not have a victim there. Mr. Glazier.
Yes, Your Honor. I would just indicate that the guidelines in this case, I tried to make it real clear to my client what the guidelines were. There was a Cobb's plea that this would be within the guidelines. And I gave him these exact guidelines as what it would be, what the guidelines would come out at. So he was aware of what was going on. This is an unfortunate situation, Your Honor. If you read the the PSI, you'll look and see that, my client, it was a situation where the mother talks about how Christopher does not have a lot of experience with babies. This is his first child. She's been trying to teach him how to care for a baby. She stated she has never seen Christopher become angry when frustrated. It's a situation where he was not even supposed to be watching the baby that day. It was going to be not his mother-in-law, but actually his girlfriend's mother was, and something came up, and so he ended up having to watch this baby on his own, which for a normal person doesn't sound like a big problem. Most people can handle a baby. The situation with my client, Your Honor, is he's a 51 IQ, and I don't see where, I think that's referred in the police report. If not, you can look at the psychological evaluations, and it puts what his IQ is in it.
He says he can't.
If you run the test that was given to him at that time, that puts him at the level of an imbecile. He's characterized as an imbecile under the IQ test, a score of 51.
Okay, that was the thing. He keeps calling him an imbecile. Like, I know that used to be a term that was used, but I don't think that is an acceptable term anymore, is it? Please, someone in that industry correct me if I'm wrong, but I am pretty sure that it's not okay to call someone an imbecile, that there's more politically correct words to use. Oh, there's a cat, and it's a tortie.
He doesn't have a lot of control over some of the things he does. You know? He's always had some limited learning abilities and coping abilities and all sorts of things throughout his life. If you want to hear him in detail, his mother's here, and she'd be more than happy to explain to you all the problems he's had growing up as a child and as an adult. They've done the best they can to treat him as an average, ordinary child. And that's one of the reasons when he communicates, he talks fairly well. You would never guess that he has these limitations. I was quite surprised when I saw what his IQ came in at. I guess the point is, Your Honor, you can see he's taking medication on page 3. That's where I was reading from before. For his issues. But nobody, the prosecutor, or not the prosecutor, the probation department recommends 15 years to 50, which is within the guidelines. I can't imagine that he wouldn't parole out early, parole out on time. This is not a vicious murder or a vicious child abuse case or anything of that sort. It was a situation where if a jury finds, not that he intentionally, but that he knowingly caused harm to a child, that could be bootstrapped into a first-degree murder, and he'd never get out. He'd be in there for the rest of his life. And he knew, and I think he knows, and I think he understood that he couldn't risk that, and that's why he took this plea. Against my advice, I still would have preferred to have had an independent evaluation. That being said, Your Honor, my client has suffered as big a loss as anybody in this case. Now, granted,
for those of you interested, former President Donald Trump just pled not guilty to the 2020 election charges. Breaking news, breaking news, breaking news.
It was because of some circumstances that he was responsible for, or at least that he couldn't control. And that's unfortunate, but he's lost his only child, Your Honor. His only child is dead because of the mistake that he made. And that's a hell of a punishment. We would ask the court to go to this screams out to be at the low end of the guidelines. This should be the 11 years, 7 months, or 10 years, 7 months, whatever it comes out as the number of months under the guidelines.
Really?
That's when he should be eligible for parole. And if for some reason the parole system doesn't parole him out quick, I just can't imagine him spending 50 years in prison for this. for a mistake on his part. It's tragic, not only for the mother, who I guess isn't here today, and for, obviously bad for the child, it's bad for everyone. But it's likewise very, very bad for my client, guys. And I'm sure.
Neurodiversity now.
I don't have legals.
Sounds like
Mr.
it.
Dietos,
Yes.
is there anything you'd like to say on your own behalf?
I wish Brittany was here so I could apologize to her, but I can see she's not in here. I wish her nothing but the best, and I'm so sorry for what happened.
Ms. Arnold, anything on behalf of the people?
Oh, no, thank
Bacon
you.
baby.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. Ms. Adams, I do not have notice of right to appellate review.
Okay, sorry.
The criteria and the reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. These are the very worst of the cases that come in front of the court and that the attorneys have to represent anytime a life is lost. It affects everybody, but most importantly, the people who lost. And in this case, Mr. Dietos, you also lost a child due to your behavior, and the mother lost a child, and looks like she probably couldn't even come to me. So based on the fact, she probably just can't deal with this either. Because I can see your client struggling as well, but I do see people in the courtroom, so I'm assuming her family members are here in support. And then Mr. Dietos' family is here as well.
It is. It is all the way around.
Sentence of the court that you serve a sentence with the Michigan Department of Corrections of 156 months to 600 months for the child abuse charge, and 4 years, 9 months to 15 years on the homicide charge. Those will be served concurrent. We have an updated credit.
Yes, 334 days.
Credit for 334 days. And I can order restitution here today.
Yes,
Okay,
I didn't have, oh, yes, I did, yes.
okay. I've just not had that before. Ms. Arnold, do you have any input on that? I've not had that happen before, and I'm sure Ms. Holly's right. I've never had restitution.
Yeah, I thought it was typically ordered as a condition of parole, but I don't think it's.
So what I'm going to do is I'm going to order $130 crime victim rights fee, $68 state costs, $60 DNA fee. As a condition of parole, you'll be required to pay $1,370 in restitution to the Michigan Department of Health and Human Services. There'll be a state supervision fee of $30 per month without monitor and $60 with monitor. And during, under the jurisdiction of the Michigan Department of Corrections, you'll obey and comply and complete all programming recommended. I know that for all the family members here, I mean, I lost a brother. There's nothing like the loss of a child. So I recognize how hard it is for everybody. And I'm sorry for everybody's loss. These cases just don't ever get better, and I'm sorry. So, Mr. Dietos, you do have the right to appeal this sentence. My bailiff's gonna hand down to you 3 copies of your notice of right to appellate review. I want you to initial and date 1 copy for my records. That's just to let me know that you received your paperwork. So go ahead and do that.
Thank you so much, Alan Scott. Thank you. Means a lot. Thank you, Stormy.
Yes, did you go to, was that 13 years? She did.
So, yeah, Mr. Dietos, I didn't exceed the recommendation. So you signed that one just to acknowledge you received your appellate paperwork. If you decide that you want to appeal my sentence, you would fill out the information on that paperwork. You could do it today. You can do it and have it sent over by kite from the jail if you want, or you take it with you to the Michigan Department of Corrections, but you have 42 days. If you decide you want to appeal my sentence, you would fill out the information on the form and mail it to the address listed on the form within that 42 days, all right?
Okay.
Like I said, you can do that before you leave today if you want. I wish everybody healing and good luck in the future. Thank you.
Thank you.
So he would actually have to appeal. He's not able to withdraw his plea because she did stay within the guidelines
I'm talking.
for the bottom end of his sentencing. So he has no option. He had to follow through with it. It is what it is. There's nothing he can do to take it back. It's final. So he was sentenced to 156 months to 600 months. And I just did that and I forgot what it was. 13 years? 13 years to 50 years. 13 to 50 years. So after 13 years, he'll be eligible for parole. Most he will spend is 60 years. So what did you guys say? So 60% think that he should have been sentenced the same as an average person and 40% said no. I was just curious what everybody thought. There was a lot of like, I don't know, variables in the situation. Is he capable of understanding? Like really capable of understanding? Did he know ahead of time that was, if I shake the baby, then this is going to happen? Because that's part of what criminal responsibility is knowing that what you're doing is going to cause something bad to happen. So that's where I started to question things. So that's all. I appreciate you guys so much. I can't believe we got to 10K, and I know I joke, but I know most of you don't like listening to me talk. You like subtitles and quick, easy cases. But every once in a while, it's nice to sit down, chill, and have a little social hour while we watch something that's a little controversial and see what everybody thinks, because we don't always agree. And it's kind of cool to be able to have a conversation with somebody who doesn't agree with you and have a civil conversation about it. So it's something different. That's probably right. So did he know right from wrong? He knows shaking a baby is wrong, and so that makes sense. That would make sense. Well, that's good, because I could talk all day. Boy, the stories I could tell you. Like taking Penny to the vet. Oh my gosh. There's nothing like going out in public when you don't go out in public very often and looking down and realizing you forgot to put a shirt on. Like you're still walking around in your tight little undershirt that you wear around the house because nobody's ever there. And you're sitting in the vet's office with nothing to cover up with. And the cute vet is the one that's coming in today. Yeah, the guy that you never get. You always get the women. Women are fine. You can wear like no clothes in front of a woman and it's fine. But nope, you got to get the guy. Yeah, that was fun. That was really fun. MS brain sucks, man. Let me tell you. I have forgotten so many things. this past week. I swear I would forget my head if it wasn't screwed on. It has been bad. Stress kills. But Penny is good. She just has bad allergies, so she had to get an allergy shot, and she needs to go on a diet. Diets are important. So she's going to start going on a diet. What was the other thing? It was a $400 vet bill. That was fun. That was really fun. Oh, and then the other thing I did. So I decided to start a blog because I have lots of stupid stories about my MS and trying to figure things out and doing stupid things like that I like to share with people. But when I share them on here, then I get lots of negative comments about, well, we don't really care about you being sick. But then there's other people who are like, oh, wow, that's really cool. I have the same problem. Oh my God, it sucks. But I don't like the negative crap. So I thought, okay, well, maybe I'll move it to somewhere else. We'll relocate the health related stuff. So, here's the court stuff. Here's the health stuff. Let's not intermix it. Just like I don't like my food to mix on the plate, same thing. So I set up the website. I'm setting it up. I'm going to get the very first person to look at it to tell me if it looks okay. And I'm typing out the URL when I realized I did only Meg, like OnlyFans, only Meg. What was I thinking? I was going for just Meg, but that was already taken. So they suggested only Meg. And I thought, hey, that's cool. Until I typed it out and I was like, oh, well, I'm definitely not trying to start an OnlyFans site for me. And that's what it comes off as. So yeah, oops. But hey, it's there. My blog is only Meg. So, whatever. It is what it is. It's me. Oh, Lord. Definitely not what I was going for. But like I said, I have had MS brain for the past 2 weeks, and I don't even know how I am functioning today. I don't know how I compiled that video without screwing something up. So if you see a lot of typos, a lot of words that don't make sense, yep, that's me. Yeah. I didn't think it was that funny, but maybe I should start charging a fee, $19.99. Only Meg. I'll tell you all my deep, dark secrets, like how I tripped on the way to the bathroom in the middle of the night and busted my ass. It was awesome. No, Siri can't understand a freaking word I say. I have to go back and correct so many things. When I try to auto type, you should see the messages. They don't even make sense. And I never thought I had an accent. I was quite positive I didn't have an accent. I mean, there is no Florida accent. Florida doesn't have an accent. And it's definitely not Southern. But I can't talk. And it doesn't help lately. I've got cotton mouth from whatever medication decided to start acting crazy. So every time I try and talk, it's like I have cotton balls shoved in my mouth. And even when I drink a bunch of stuff, yeah. And then I get 5,000 comments. Oh my God, you talk too slow. You talk too fast. You talk too slow. Why don't you use an AI voice generator? Well, because I'm not lazy. Well, I kind of am, because that takes way more work than just talking. So deal with it or go somewhere else. I don't know what to tell you. And while I'm ranting for no reason, sitting here talking to you all, that's Florida men. Florida men show up in news reports. It was her yearly shots and medication and the allergy shots and all of that. It was all kinds of stuff. Who goes to a YouTube channel, watches it, doesn't like it, and decides to leave a comment and tell them how horrible it is because it's not their thing? Like, if it's not your thing, change the channel. Go somewhere else. Go find something you like. Like, why would you go on someone's channel and say, hey, I don't like this? I can't process that. I can't process going with the intention of being mean to someone else. What purpose could it serve you to go and intentionally hurt someone else? When all you have to do is, it takes more effort to go type this up and be an asshat than it does to change the channel. I don't get it. I don't. And I would love for someone to explain to me why people do this. I mean, I know the whole, it makes them feel better to make people feel bad and all that, but it has become a culture. There's so many people that do it that I can't, it's got to be more than that. Right? Like, I make sure I don't talk over videos. I don't talk over videos unless it's something like they're repeating themselves over and over again, saying something we've heard 100 times, or it's a break in it. Like, that's the big thing. And as long as I'm not doing that and I'm pausing the video to talk, like, deal with it. If you don't like talking, go to another channel, because I've already been demonetized for not talking. And I talk when I can. I can't always do it, but you know? I don't get it. I don't get it. I know. You have to have a positive surroundings, because there's so much negativity in this world that if you don't have some kind of positivity to balance it out, it will pile on you and you won't be able to survive it. You will end up this like horrible depressed mess that locks themselves in a closet and cries all day. I mean, there's really, what are you going to do? Like, you can't fight the negativity on your own. You need people around you that are positive. And that's kind of why I wanted to start the website, because I know Discord is like way overwhelming for a lot of people. I do have a Discord. Anybody who wants to, welcome to sign up, chat there, whatever you want. If you want me to make a room, whatever. On the website I did set up a forum for people to communicate back and forth, because there's so many of us that have autoimmune diseases and other limitations that make our lives difficult on a daily basis. And it's nice to have a support group or just someone to help keep you positive and uplifted, because that is what really got me through so many hard times. And tell Mom that she's always lovely and I adore her. I do. She is a sweetheart. And so are you. It's the blue eyeshadow. I didn't even realize last time I had the blue reflection in my glasses, and as I was getting ready, I thought, hey, I'm gonna put on some funky eyeshadow just to, celebrate 10K, because 10K, WTF, like, really? How did that happen? I have no idea. But I don't like the mean girl persona. I want something positive, because my life sucks half the time. Things go wrong every single day. If it can go wrong for me, it probably does. So I need somewhere to go for some positivity, and that's what I would like. And I have several autoimmune diseases too, and they hit me like a ton of bricks a couple of years ago. And I went from having this normal life with a normal job. I had just got my master's degree. I was on track. I was ready to go. And all of a sudden, like, boom, I can barely get out of a chair. And COVID hit. And life got turned upside down. So I've had to relearn how to live with all these limitations. And now I am on my own with, a teenager trying to learn all this stuff. And it's not easy. And I stumble and I fall, and I like to share stuff. I used to be the type of person that I had the Facebook life, You only got to see the pretty on Facebook. You never got to see the real stuff, because it was bad. We hide that. All you get is, the pretty pictures. Look, I went on vacation, and then we had dinner here, and then we went as a family here. Yeah. At this point in time, let me tell you, I tripped and fell and did this. And then this time I coughed and I peed my pants a little. Oh my God. What the hell? Life sucks sometimes. Let's talk about it. So, TMI, I know, but hey, you know, it's life. I'm tired of sugarcoating things. I'm tired of pretending everything's okay when it's not, because it's not. It's not okay. Shit sucks sometimes. So let's share and support each other and say, hey, you know what? This happened to me. Laugh about it, support each other, and move on, because that's what friends are for. And then we can switch back over and watch Little Court. So if you're interested, it's only Meg, and I might switch over to the YouTube channel so I have a place to ramble, because, you know, everybody here got mad and turned it off as soon as I started talking. You watch the numbers dive. It's hilarious. I should show you guys sometimes. The second I start talking, like, the numbers just go, whew. But there's a forum there, because Discord gets overwhelming. I don't even know what to do. I have like 2 channels that I can manage to talk to people on, and other than that, I get a little overwhelmed. So, also, oh, the other thing that I forgot that probably isn't even going to make it to many people since it's so far buried in here, and I'll post something in the community page. A couple of you asked me to post something where you can ask me questions and I will do the research for you. You know, things that you're too lazy to Google yourself. So in that, on the website, in that forum, I put something called Ask Meg. So if you have cases that you want me to look into, cases are going to take a lot longer, I promise you. I am not as quick on cases as I am other stuff, but I will happily dig into some stuff for you and do a little stream with a summary of all those things. So I'll put one on Discord as well. If you have any questions, feel free to throw them up there. It's not a stump Meg because, you know, no, but things that you want researched, things that you don't understand, like why are the courts have different names, or, you know, I don't know. It could be whatever you want. I can't think of anything right now. Y'all can think of it. That was the whole point. So anyways, I can't believe we have 10,000 subscribers. I never expected that in a million years, and I appreciate you all more than anything. And the dogs appreciate you watching them sleep. And before the next time, I will get some catnip and put it in the cat tree. By the way, that cat tree is like awesome. It is solid wood. Unbelievable. Best cat tree I've had. I've had like 10 cat trees. This is the only one that's actually lasted, and it was outside forever. And now I brought it back inside for now, and oh my gosh, it's like solid. So I'm gonna put some little catnip in there, and you can watch them go crazy next time. Because, you know, lighten things up a bit. You want me to just sit here and talk all day? I could totally sit here and talk all day. But I don't have things to talk about. I mean, I probably do, but like my brain's not working, so I need prompted. I don't know. They do, except for Penny's new thing is she sits there and she waits for a cat to get close, and then she's like, arr! I'm like, what the heck? She'll, in the middle of the night, everybody's sleeping, cat's sleeping, we're all cuddled up, it's all sweet, you know, because 4 out of 5 of us sleep on the bed. Psycho Lola won't sleep on the bed unless she comes and goes, but her and Rambo switch off on who can be on the bed. She's only nice in the middle of the night. Any other time she stares at me like she wants to like eat my brains. She's scary. But in the middle of the night, loveliest cat in the world. Until you touch her and move real quick, you know. Oh God, if you sneeze, you'll end up with scratches everywhere. But she'll get up on the bed and she'll slowly come over and want pets, and I'll pet her twice, and then Penny, who's passed out, will like fly up in the air, pounce up, and do that to her. I'm like, what the? Why? Why do you all of a sudden hate cats? But during the day, they play and they're best friends. So I don't know. I don't understand it. Maybe she's trying to, you know, dominate and be the queen of the house? I don't know. I really don't know. Oh, thank you so much. I don't understand it at all. I don't get it. My mother would probably agree. She has no idea why. Thank you. Thank you. It's because of you guys. It's definitely not me. And I think it's probably more Penny than me. When I went to the vet yesterday, we were checking out and they said, "Is that Penny?" And I said, "Yes." They're like, "The Penny?" And I was like, "Oh, you watch my YouTube channel?" They're like, "Oh, no. When she was in here as a puppy, we took a video of her sitting at the desk typing and put it on TikTok, and it was like super popular." I was like, "Oh, of course." Yeah, everybody likes my dog, not me. 120-pound terrier, there is like no way. How do you deal with a dog that big? I struggle with her. She's 22 pounds. I can't even pick her up and put her on the bed. We have to do like this joint thing. Okay, you jump and I'll help. My daughter has 2 huskies that are 80 and 100 pounds. They're massive donkey beasts. Sweet as pie, but huge dogs. I can't do huge dogs. They're too much for me. I'm not sure why. I mean, I love dogs. I love any dogs, but I don't think I could have big dogs in my house. I think it would be too much. And oh my gosh, with the fur. Oh, with the fur. Oh, do you want to learn something new? Did you know dogs can have hairballs? Like, serious. Like, dogs can puke up a hairball, Paul, just like a cat can? And that's normal and that's okay? Like, what the hell? I had no idea. We're getting ready to go to the vet, and all of a sudden, Penny starts puking. I'm like, "What's wrong with you? You haven't even eaten." And she pukes up the treat I gave her. Okay. And a hairball. Like, what the heck? A hairball? And so, of course, I took a picture of it. And then while I was at the vet, I was like, "Here, look at this. What is this? Is this okay? What's going on? Why is she puking up hair?" Well, she's got allergies. So when she goes outside, her paws start to itch. So she starts licking her paws. And she doesn't shed a lot. So she must be licking the cats too. I don't know. But she had this whole hairball. He's like, "Yeah, let's give her an allergy shot so she doesn't lick anymore." I was like, "Oh, okay. Hopefully that fixes it." Well, first he asked me, "She didn't like get your hairbrush or anything." I was like, "I don't think that's what that is." He's like, "Oh yeah." Yeah, no, can't do shedding. The 3 cats drive me crazy. They really do. It just, but the litter box, oh my gosh, the litter box. It's magic. It's unbelievable. Like, I have never in my life experienced something so amazing. It's that super expensive one that tells you every time your cat's in it and how long they pee for and all that crap, which I don't even care about. But it's the spinny ball one. And it's the first automatic litter box I have ever had that actually works, because my son decided he just can't effectively scoop litter boxes and I can't get down and do it. So we thought, okay, we're going to try this. And wow, I'm amazed. I've never had an automatic litter box that works. I haven't. And this thing is fabulous. For the first couple days, the cats just played in it the whole time. And I couldn't figure out how to turn the alerts off. So my phone kept going off nonstop, telling me who was in there. But finally, they got to using it. And it goes straight in a garbage bag. And you just take the garbage bag out, throw it away, put another one in. Everything's all clean and nice and pretty and smelly. It's even got an air freshener in it. There is a spray air freshener in the litter box. OMG. Why didn't we have this years ago? I'm in heaven. So I actually built a big cover for the litter box and all that, but it was, yeah, I actually put a link to it on the webpage I created down. It's down at the bottom on the right. like the web page is really like very raw. I just did it in a couple days. I haven't put a lot of effort into it, but I thought, okay, sometimes I am really into finding things that make my life easier. Completely. That's huge. I don't like complicated things and things that stress me out, so I go looking for things to simplify. Simplify every process, simplify every possible way. And that, between that and the vacuum clipper thing, it has made life so much easier in so many ways. I can't tell you. I tried to put Ziggy in it to see if maybe he'd use it. He wasn't going for it. He looked at me like I was crazy, but you know, we'll see. I'll find something that works, you know, at some point. What are you guys doing? It's like kids, when it gets really quiet, they're doing something. Something's wrong. Quiet. Somebody's in trouble. They're not sleeping, so they must be getting in trouble. Come on. I know. Come on. Come on. Come on. She has to shake her butt and look at me and wiggle like 10 times before she can jump up. Can you say hi? Yeah? Say hi? Say I got my shots. I'm good to go. Good to go. Yeah? Can you tell everybody thank you? Look, over here. Psst. Over here. Look at the camera. Say thank you for loving us and supporting us and being awesome. We appreciate you so much. And I don't have a good setup right now. I'm still in the process of moving, but you know, you got to find a place to move to before you can move out. All my stuff's packed, so we're kind of like working on skeleton equipment here, but I'm definitely going to do more lives once I get set up with like an actual studio room, something where I don't have to set things up every time. And maybe I'm going to start doing some more. In the meantime, if I do some on the more talking, less court, I will post them on the website. Court stuff I will post here, as always, on YouTube and the Facebook and all of that. Where are you going? Yeah? Do you not like me? Okay, but I appreciate you guys so much. I really do. Your support has meant the world to us over the past couple months, and I don't know what to say. You're awesome. You are awesome. I couldn't ask for a better community and group of people to hang out with and watch the TV I love to watch and comment on it. It's nuts. Absolutely nuts. I don't get it. What are we doing? They'll never. Oh, Oh, who are you talking about? Who are you kicking out? I missed it. All right, Austin, you'll have to tell me later because I can't find it. Oh. All right. So you guys have a great rest of your afternoon. I have another video, I think, queued up that I will post later tonight. I will be following up on the 34-year eviction guy. Oh my gosh. Like, I have so much to say about that. And I'm sorry, it was kind of a downer case, but it was all that I had for start to finish. And I hope you guys understand it was more about the legal aspect of the case than it was what happened, because we all know that that's tragic, but you know, there's still a process of justice that has to go through. So I hope everyone has a great afternoon, and thank you again for everything. 10K, we hit 10K. Oh my gosh. Take care, everyone.